Señor, usted tiene una orden de arresto del gran jurado
alleging one count of conspiracy
donde se alega un cargo por conspiración,
one count of transportation or sale of narcotic drug.
un cargo por transportar o vender drogas narcóticas.
Both of these are Class 2 felonies.
Ambos son considerados felonía clase 2.
One count of illegal control of an enterprise, Class 3 felony.
Un cargo que es categoría clase número 3, felonía, de mantener algo ilegal, un intercambio.
These allegedly occurred December 17th of 2023.
Esto alegadamente pasó el 23 de diciembre del 2023.
I've appointed a lawyer to represent you.
He asignado un abogado para que lo represente.
Your next hearing will be in arraignment September 17th at 8:30.
Su próxima audiencia sería la audiencia para el día 17 de septiembre a las 8:30.
And I've set a $50,000 cash bond.
Y he puesto una fianza de $50,000 en efectivo.
Get your paperwork from the court staff.
Por favor, obtenga los documentos del personal de la corte.
Gracias. Sorry.
Thank you.
Sorry.
All right, thank you, interpreter.
My pleasure, Your Honor. Thank you so much for allowing me to serve you.
Okay, can I have Leon Yore in the courtroom? Leon? All right, sir, state your name and date of birth.
Leon Mary Yore Jr., 12/02/2000. Your Honor, I know it looks bad.
Okay, it's 12/2/2000?
Yes, ma'am.
Okay.
Your Honor.
So let me just tell you what we have here, okay?
I know it looks bad, miss.
You know what?
I know my everything looks bad, ma'am. I know I got OR this morning. I know everything I have going on, ma'am, but I promise you, I've tried to make it to my court dates and everything.
Well, sir, I got to tell you, I don't have a lot of discretion here. So let me just go through this. Okay, so you have a warrant for your arrest by the state of California.
Yes, ma'am.
They want you back. They've already been contacted. They're going to say they're going to come get you. Now, did you read the laminated card?
Yes, ma'am.
Okay. So you have a choice to make at this time. You got one of two choices you have to make. One, you can choose to waive your right to an extradition hearing and be sent back to California within 30 days. That's option number one.
Yes, ma'am.
Option number two, you can say, I'm not going to waive my rights, and I'm going to demand an extradition hearing and that a governor's warrant be signed by the governors of both states, California and Arizona, before they can send you back to California. So if you choose, you want to say, no, I just want to waive my rights and go over there, and you want to waive your right to that extradition hearing, you will be held in the jail here, no bond, for a period of up to 30 days to allow California to come and get you. That 30 days would start tomorrow as long as you do not have any criminal charges pending against you anywhere in Arizona. If you do have criminal charges pending against you in Arizona, the 30-day period would not start until those charges are resolved. Now, if you choose to have an extradition hearing, I'm going to set another hearing in our courthouse September 22nd at 1:30. I cannot appoint you an attorney to represent you because extradition matters are civil in nature, but you would have the right to hire a lawyer at your own expense if you choose. Now, you are entitled to bail in this case. It would be $50,000 cash.
Yeah.
You would not be entitled to, if you are unable to post your bail, you will be held in custody during that time or until another judge would modify your bail. A governor's warrant signed by the governors of both states requiring to extradite you can take up to 90 days. Do you know what you'd like to do? Option 1 or option 2?
Ma'am, if I say here, ma'am, my next court date wouldn't be till 10/23 for the charges that I do have pending out here. And I got OR this morning, ma'am.
I know, that has nothing to do with this.
Okay. So so I would sit until my next court date, which is 10/23, miss?
Again, if you waive your right to an extradition hearing, you're going to stay in custody for 30 days, and then California has to come get you and bring you over to California.
Okay, but and then from there I would handle that, and I would have to come back for that court date next month for out here.
I don't know anything else about what other court dates you have.
I have a court date for October 23rd, ma'am.
I know, but all I know is on this case.
I don't want to make the wrong decision, ma'am.
I know. So what you can do is say you're not going to waive your rights.
That would take 90 days, though, miss.
It could be 90 days, but you can always change your mind because you're going to have another hearing in about 12 days.
And if I say yes, they would come get me within 30 days, ma'am.
It would be 30 days from that date.
And so would I have to, so would they send me back out here, or would that case be?
I really don't know.
Or would
I really don't know what would happen.
I don't want to make the wrong decision, ma'am.
I know, if you don't know what you want to do, I can't accept a waiver, so I'm going to say you're not going to waive your right.
If I do go, that'd be 30 days, right? I was sitting here for 30 days until California comes and gets me.
Yes, if they don't come get you in 30 days, you get released. They have 30 days to come get you. Sometimes it's quicker because they're next door. Sometimes they'll wait for the very last day. I can't tell you. But if they don't come get you, all I know is on the 31st day you get released.
Okay, and ma'am, when would the 30th day be, if you don't mind me asking, ma'am?
Well, it would start tomorrow, which is going to be the 11th.
Okay. And
let's see, 30 days has September. I've tried 19. It would be around October 11th or 12th, something like that. But, sir, if you're unsure, waiving your rights to that hearing is a big thing. So I got to make sure that you understand what you're doing. Now, you will see another judge in 12 days.
Option 2 is the governor, that would be take up to 90 days, correct? Option number 2, right?
Yeah, take up to 90 days. That's correct. But what I'm saying is you can change your mind and waive it on that next hearing if you sit and think about it.
Is that an option, ma'am? Can I sit and think about it, miss, till the next hearing?
Okay, I'm not understanding what you're saying.
Is that an option? Can I sit and think about it till the next hearing?
I can't really understand what you're saying.
Is that an option, ma'am? Can I sit and think about it until the next hearing, ma'am?
Well, yeah, you can waive your rights when you see another judge on the 22nd.
And if I waive my rights, it starts now, right now, correct?
If you waive your rights today, that 30 days starts tomorrow. But now you're telling me that you have pending charges?
No, out here, yes, ma'am. I just have I was OR'd for the case this morning, ma'am.
Yeah, but if you have pending charges, those 30 days might not start until after that's done.
That's what I'm saying, ma'am. My next court date is not till 10/23. That's what I'm trying to explain to you, ma'am. That's what I'm trying to explain to you, miss. That's what I'm trying to explain to you, ma'am.
You know what, sir, I really don't feel comfortable taking a waiver from you because I don't think you know. Did you get a lawyer appointed for you at that next hearing?
No, ma'am. He just OR'd me, ma'am. The judge just OR'd me. He just OR'd me, ma'am, and told me he promised I'd be.
And when is that next court hearing?
Next court date is not until October 23rd, ma'am.
When is that next court hearing?
No, it's not till October 23rd, Miss.
October 23rd.
Yes, ma'am.
The only thing I can say to you is that on the 22nd and 12 more days, you can tell the next judge that you've got another hearing on the 23rd. I don't feel comfortable because
I know, Miss.
I know. I don't think you should waive your rights.
You see what's going on, ma'am?
Because I don't think you legally understand this. So I'm going to say you're not going to waive your right. I'm going to set your bond. It's going to be a secured or a cash bond of $50,000.
Can you please lower it, ma'am? Could you please lower it? It's already $25,000 out there, miss. It's already $25,000, ma'am.
And then when you go to the next judge, you can ask the judge to reduce it.
Please, ma'am.
No, sir, this is my only two options that I have. It's not up to me. California has requested that they're going to come pick you up on these charges.
Okay, yes, ma'am. And so I know you said you don't feel comfortable because
I really don't. So you're going to see another judge in 12 days. Okay? All right, you're going to get your paperwork. Court staff will bring you your paperwork, okay?
Yes, ma'am.
All right.
Can I ask you a question? So if I do have pending charges, I would sit all the way until that's finished, right? At my next court date, which is 10/23, correct? Right?
Even if you waive, the 30 days would not start until
that case is over with.
Correct.
And you don't feel comfortable doing that, correct?
Well, no, I don't feel comfortable with because I don't think you really understand enough about this to waive a very important right. So make the state get the warrants. That's going to start right now.
Okay.
That 90 days is going to start right now. Okay? And you could be waiting 90 days for that other case to be disposed of, because if you don't have a hearing till October, it could take 30 days. If you get acquitted, that would be the end of it. But if you have a sentencing, that could take another 30 days. So you're better to get this 90 days started right now.
90 days. So I have to wait.
Okay.
I have to wait here 90 days, ma'am.
Well, I don't know if it'll be 90 days, sir. I really don't.
But you
can talk with the next judge in 12 days.
But they are coming to get me, though. California is coming to get me.
They'll be notified that you are now demanding that both governors sign a warrant, okay?
And that's for that warrant is for California.
That's the part that they only have 90 days to get.
So I'll be held for 90 days. Unless
you post the bond. And the next judge, you can ask the next judge to reduce it if you want.
With that.
All right, I need to move on, but you're going to see another judge in 12 days, okay?
Okay, ma'am. So I'm going to sit for 90 days, ma'am?
What I said is, the other case could get dropped. You could get another judge that lowers this and you could bond out. There's so many variables, I can't tell you what's going to happen right now.
And if I do waive my rights and I start the 30 days today or tomorrow,
you still got to wait for that other case to see what they're going to do on it. Okay. I'll try this one more time.
Your call has been forwarded to an auto.
Oh, that's not happening. Okay, let's have, this one will go quick. Raphael, come on in. And are we clear back there?
Yeah, we got one more, that's it.
Okay, sir, state your name and date of birth.
Rafael Anthony Jorge Hinojosa, 72585.
Okay, you've got a grand jury warrant, which means the grand jurors met, they heard testimony, they found probable cause on one count of failure to register as a sex offender. That's a class 4 felony. This allegedly occurred November 2nd of 2023. I've appointed a lawyer to represent you. Your next hearing will be an arraignment, September 17th at 8:30. The grand jury judge set your bond at $1,000. It's not cash. You can go through a bonding company.
Awesome.
Okay?
Thank you, Your Honor.
Okay. And then Tong Nguyen.
You pronounce it Win, Your Honor.
Hi, counsel. Sorry, but we usually take these at the end.
Not my first rodeo, Judge. I get it.
Okay. All right. Sir, state your name and date of birth.
First name is Toon. Last name is Nguyen. Date of birth is 10/28/1999.
All right. And counsel?
Good evening, Your Honor. Sean Call appearing on behalf of Mr. Nguyen, who's present in custody, standing to my left.
Okay. So, sir, you've got a grand jury warrant, which means a grand juror met. They heard testimony. They found probable cause on 4 counts of sexual conduct with a minor and 2 counts of sexual exploitation of a minor. All class 2 felonies. There's various dates of offense. October 1st of 2023, October 2nd of 2023, January 1 of 2024, and February 7th of 2024. I didn't have enough information to determine whether you're indigent or not. Now, I know you have an attorney here. If you don't work something out with your attorney for him to represent you, then when you go to court the next time, you have to fill out a form to see if you're eligible for a court-appointed lawyer, okay? So at this point, given that I didn't have that form, you're not precluded from doing that, but I can't appoint you an attorney without that form, and you have counsel here, okay?
I'll explain that to him in greater detail when the hearing's over, Judge.
Okay. And then we do have the county attorney on the line, correct?
Yes, Your Honor. Ashley Stetson on behalf of the state.
Okay. Counsel for the state, did you want to be heard?
Yes, Your Honor, very quickly. Your Honor, the state is asking for bond to be affirmed. As Your Honor stated, the grand jury did meet on this matter. A judicial officer did hear this. Given that it is a grand jury case, the state is not privy to the facts of the case. However, this does appear to be a very serious allegations. Based on the seriousness of the allegations, based on the fact that the state, as well as the court, has very limited information on this, and the fact that the judicial officer of the grand jury did hear it and did decide that $150,000 secured bond was appropriate, the state is asking for that to be affirmed. Thank you, Your Honor.
Okay. And counsel.
Your Honor, I would want to address the release conditions if I could, just with some additional information. I understand it's a grand jury warrant, but just some additional information that I'm confident was not at the judge's disposal at that time. Obviously, Mr. Wynn is 25 years old. He has no criminal history whatsoever, no misdemeanors, no felonies, no nothing. While he does originate from Vietnam, he is a U.S. citizen, has spent 13 years in Maricopa County. His parents have been here even longer, and that's who he resides with while he's out. He and his wife both live with his parents. So they do have roots here in Maricopa County, which I think speak very loudly to him not being a flight risk in this case. He works full-time as a mechanic for AutoNation. His next shift is on Friday. If he's not there, he's very likely to lose his job. He's the primary provider for his wife, who is a full-time student. So obviously, holding him past Friday would have serious ramifications on his family. He would be returning home with his parents. Were any minors in the home?
Yeah.
There are no minors inside the home if he was to return to his family. Now, based on the nature of the charges, I explained to my client, I don't think I could come in here and save face and ask for something without a bond. However, $150,000 is something that he absolutely cannot post. A bond that I'm recommending based on everything is $75,000 secured. Certainly, if he is released on that bond, it presents a major financial incentive for him up here. He told me that being able to post that bond would be a stretch, but he thinks it's at least possible, whereas $150,000 absolutely is not. He would be on the ankle monitor pursuant to statute, and I think some important facts for you to consider, Your Honor. These allegations are approximately a year and a half old, and there's been no allegations or police contact whatsoever over the last year and a half. There's been no alleged contact with the victim in this case. Again, for me, information is also limited, but my limited understanding is the contact with this victim originated from an online interaction. It's not somebody that he would have an occasion to see on any sort of a regular basis. He doesn't have a close personal connection with her, and hence has had no contact for over a year and a half. That would continue if he is able to post that bond as a release. So I certainly understand the things that the court has to consider. I don't believe he's a flight risk. I don't believe he's a danger to the community at large. And I don't believe, especially if on an ankle monitor with a $75,000 bond hanging over his head, he would present any risk to the victim in this case and would comply completely with any orders to have no contact with her whatsoever.
Okay. Does your client have any children of his own?
He does not have any children of his own.
Okay.
I do not plan to.
You don't plan? Well.
And does his work involve any type of internet usage?
Do you have to use the internet at work, or are you hands-on with cars all day?
Hands-on call, but we had to go into computer for technical work.
If you had to at your job, could you stay off the computer? Could you do your job without having computer access?
Yes.
You could just work on cars?
Yes.
Okay. Your Honor, as I'm sure you overheard, my client's informed me that while he does use computers at work, I suppose I would ask if there's internet restrictions on him if released, maybe an exception for while he is at work. But he did make it sound like it would be possible for him to continue working as a mechanic without accessing the computers in the office.
Okay. So given the fact that the grand jury judge set it at $150,000 and know a lot more about this case than I do, at this point I am going to affirm the bond. It is secured. It's not cash. Pursuant to Arizona law, you will have to be on electronic monitor. I did a curfew, not house arrest. Times on your curfew will be determined by your pretrial services, okay? Typically, not all the time, typically, it's to see your counsel, it's work, things like that, all right? You are not to have any contact with the alleged victim. You are not to have any contact with any minors. You are not to access the internet through any electronic means, with the exception that I will allow you to use the internet while at work. Okay? All right. Is there anything I'm missing from either counsel?
Not missing, Your Honor, but if I could just clarify the record again, that your ruling is without prejudice and he could still raise the issue regarding release conditions.
Okay, say that again?
That your ruling is without prejudice, so he could raise a motion to modify.
Oh, absolutely. You can always do that. I mean,
I like to just make the record.
Yeah, obviously. I mean, I don't know this with a grand jury warrant, so typically we do affirm those, but you can always take it up to the next judge. And then also remind your client about filling out that financial form if you do not work out anything on your representation.
I'll do that, Your Honor. Thank you.
Okay. Anything from counsel for the state?
No, Your Honor. Thank you.
Okay. All right. We're in recess.
And Your Honor, can the state be excused?
Pardon?
Can the state be excused?
Oh, absolutely. Sorry.
That's okay. Thank you, Your Honor.
Kind of hard for me to excuse you when I can't see you anyways. Take care.